Honorable Principal Ma'am, and my dear colleagues. Today, I want to throw some light on the topic of juvenile justice. So, first of all, we have to understand what is the word juvenile means. Juvenile word is given, it is used for such individuals who has not yet attained adulthood. So, in India, children who are below 18 years of age are considered as juvenile, and it is different for various other countries. This age is different. So, what is juvenile justice now? The system of laws, policies, and procedures which are intended to regulate the processing and treatment of non adult offenders for violations of law and to provide legal remedies that protect their interest in situations of conflict or neglect is called as juvenile justice. As it has been correctly said by Margaret Mead, that children must be taught how to think, not what to think. A child will always carry whatever memories have been initiated in his mind. And we all know that the destiny of mankind is in the hands of today's children. There always exists a preconceived notion for everything in the world. Hence, the same for the juveniles, that they should be dealt calmly and leniently, as young folks have a tendency to adopt aggressive approaches to handle a chaotic situation in their life. There are many reasons which affect the physical, mental, as well as the overall development of a child, such as poverty, family tensions, parental care, faulty education system, social values, and so on. In a developing country like India, the youngsters, which are assets for the society, have started becoming a liability. Crimes committed by juveniles are also increasing in the past few years. Nowadays, the children are also used as a measure to do unlawful or illegal acts because of the innocence and manipulative behavior. They can be used and lured easily by criminals around them. So, punishable offences that are classified as criminal offences for adults, for example, murder, robbery, and theft, are referred to as delinquency when committed by juveniles, whereas juvenile offences mandating legal intervention only, for example, alcohol, tobacco use, truancy, and running away from home, are referred to as status offences. So, children are also subject to specialized laws, procedures, and policies designed to protect their interest when parents or other legal guardians are unavailable, negligent, or involved in custodial disputes. Now, let's take a look at the history of juvenile justice. The term juvenile justice was used for the first time by the legislator by the state of Illinois, USA in 1899 while passing the Juvenile Court Act. A movement for the special treatment if juvenile offenders has been started around the 18th century. Prior to this, they were treated as other criminals. The General Assembly of United Nations has adopted a convention on the rights of child on 20th November 1989, which includes 4 sets of civil, political, social, economic, and cultural rights of every child. These are right to survival, right to protection, right to development, and right to participation. The convention states that there should be no legal proceedings and court trials against the little ones. The convention leads to Indian legislation to nullify the Juvenile Justice Act 1986 and to make a new law, that is the Juvenile Justice Care and Protection of Children Act 2000. The Juvenile Justice Act 2000 was enacted with the aim of protecting the children. It has been amended twice since then, once in 2006 and then in 2011. The amendment was to cover the gaps and the loopholes. After the threatening incident of Delhi gang rape case, the lawmakers were forced to come up with an essential legislation which led to the formation of the Juvenile Justice Care and Protection Act 2015. So, the categories were made terming the offences as heinous, serious, and petty. And if a heinous crime is committed by a child between the age of 16 and 18, they can be tried as an adult. This was a new development. And special courts were established that will be trying the juvenile offences only, like juvenile courts, NDPS courts, POSCO courts, etc. The scope of child in need of care and protection was also enhanced. According to the Rule 12 of the Juvenile Justice Rules 2007, The claim of juvenility is to be decided by a juvenile justice board before the court proceedings, but the claim cannot be raised before the court at any stage of proceedings and even after the disposal of the matter by the board. And regarding the juvenile justice board, it has to consist of a principal magistrate and two social workers. One of them should be a woman. The decision taken by the principal magistrate shall be final, and some special procedures are to be followed by this juvenile justice board, like the hearing must be informal and should be strictly confidential. The offenders should be kept under observation home after detention. The trial of the juvenile in conflict with law shall be conducted by a lady magistrate, and a child in conflict with law may be produced before an individual member of the board when the board is not sitting. After this came the Juvenile Justice Amendment Bill 2021, which is a very recent one. So these are the key amendments in that bill. First is that regarding the serious offences, it will also include offences for which maximum punishment is imprisonment of more than 7 years and minimum is of less than 7 years. Second is that the status of non-cognizable offence was changed. The present act provides that cognizable offence, which is punishable with imprisonment between 3 to 7 years, where the arrest is also allowed without warrant and is non-bailable, it has been amended to be a non-cognizable offence. Third was regarding the adoption. The bill provides that instead of the court, the DM or the district magistrate will issue such adoption orders. And then regarding the appeal, the bill provides that any person who has been aggrieved by an adoption order passed by the DM can file an appeal before the divisional commissioner within 30 days. Child welfare committees were to be formed. The bill also proposes that all offences were to be tried in the children's court, and the DM was supposed to be supervising the district child protection unit, conducting a quarterly review of the functioning of the child welfare committee. So with this, I hope I have covered all the main points regarding the status of the juvenile justice in India. Thank you.